problem, Mr. Liu, because you get into a situation like this one that Justice Barrett very eloquently described as feeling like fundamentally unfair. They're fighting over a $2,400 tax debt that at least 2 courts said wasn't owed, and yet they plowed ahead and got a price half the amount of the value of the property that was flipped for the value of the property. At some point, doesn't the Constitution have something to say under the rubric of what a just compensation is? Is it just to give the state that much leeway? Shouldn't the minimum require a little bit more?
I don't think the takings clause speaks to those issues. I mean, to the extent the
So what would?
Well, I think these sorts of issues about when a foreclosure is appropriate have typically been the province of federal and state statutes, and those statutes have proven perfectly competent in addressing those issues
Not here.
For centuries.
Not here. That's the claim.
Well, I think what the facts of this case show is that Mr. Pung was given notice of the delinquency. I mean, he face-to-face was told by the township assessor that he owed the tax.
And he went to tax court, and the tax court said, no, you don't. And he presented the government with that notice, and the government said, bye.
Right. And I think this is an unusual feature of this case, that while Mr. Pung did appeal the denial of the principal residence exception as to certain years, he didn't appeal that denial as to the year at issue here. I don't know what explains that choice, but it is what
All right. I have one final question. Given the 3 minimums of fairness, are you saying those are the only ones, or are you leaving open the door that there are potentially others?
We are leaving open the door that there are others. I think, as has been mentioned this morning, this is not an issue that has been the focus of the briefing. So one of the reasons we think a remand is appropriate is for any preserved issues like this to be addressed. The reason why I say it's not an exhaustive list is because while there are certain procedures that you can point to that will provide fair procedures, there's any number of things a state could put on top that would actually make those, undercut those same procedures. So I don't think it's as simple as going through and saying there's X, Y, and Z. I think you need a catch-all, and that's something like, and the state can't do anything else to kind of undercut all the procedures on that list.
So the other side is saying you can't do anything that undercuts fair market value. That's how they would answer that question. And so how should we answer it, if not that way?
Right. And I don't think the mere fact that a procedure is or is not going to have an effect on fair market value can be enough to decide whether it's okay or not.
But should it be a factor?
Whether the procedure undercuts fair market value?
In some... Yeah. Not rational way, or I don't know what
I think the guide has to be history and tradition. I think that provides the most principled way to decide which procedures are required and which are not.
All right. Thank you.